Good morning. I'm Chip Meller, President and General Counsel of the Institute for Justice, and I'm pleased to welcome you here this morning to announce the filing of the Institute for Justice's latest economic liberty lawsuit. The Institute is a public interest law firm that litigates around the country to restore constitutional limits on government power. Nowhere is that more important in the realm of earning an honest living, where today that right receives almost no protection under the Constitution, a travesty in this country built upon the notion that if you work hard enough, you have a chance to succeed on your merits. And yet that's being denied because of arbitrary licensing and permitting laws throughout the country, a veritable plague of licensing and permitting laws that stand in the way of aspiring entrepreneurs in all sorts of occupations. Today we have a very interesting occupation that is plagued by just such a licensing law. And we're here to talk about that and the filing of the lawsuit that was filed in federal court today to overturn this law. I'll now introduce IJ attorney Robert McNamara, who is the lead attorney on this case. He will in turn introduce our clients, who will make brief remarks and then be ready to answer your questions. Bob?
Thank you, Chip. The United States is in the midst of an explosion of occupational licensing requirements. In the 1950s, only about 1 in 20 Americans needed to get the government's permission to do their job. Today, that number is 1 in 3. The explosion of occupational licensing has reached the point where there's almost nothing government officials think you should be able to do without first getting their permission. And that apparently includes describe things. In Washington, D.C., tour guides who talk to their customers about things in the city without first getting the government's permission by obtaining a special license face fines and up to 90 days in jail for unauthorized description. That is un-American, that is unconstitutional, and we will put a stop to that. The lawsuit we filed today is designed to vindicate a simple principle. The Constitution protects your right to communicate for a living, and that's true whether you're a news reporter, a stand-up comedian, or a tour guide. In this country, we rely on people to decide who they want to listen to. We don't rely on government to decide who's going to be allowed to speak. That's the principle this lawsuit is designed to vindicate, and that is why we're going to win. I'd now like to introduce you to IJ's clients in this case, Tanya Edwards and Bill Main. They will share a brief statement about their own experience, then we'll be happy to take any questions. Tanya?
Good morning, everyone. My name is Tanya Edwards, and I'm one of the owners of SEGS in the city. We have brought this lawsuit today with the Institute for Justice to defend our rights for freedom of speech. Our right is currently being challenged by the DC government to actively speak to our customers as we take them around the streets and sites of the Washington, D.C. area. We're hoping for a quick decision on this case, and we'd also like to thank the Institute for Justice for their support in helping us defend this case. Thank you very much, and we're happy to take questions.
We'll be happy to take your questions as a group, or we're happy to talk to people one-on-one, whatever's easiest for you guys.
Doesn't matter to me. I mean, however you want. I do have some questions.
Sure.
Okay. What is the status right now, actually, of the licensing requirement? I mean, are these in effect? Is there a specific test that you know you would have to take, or is it something that's being put in right now?
The district issued new regulations that became effective this past July, making clear that people who give tours on Segways are required to get a license before they describe things. There is a 100-question multiple-choice test covering a range of some 14 topics, drawn from about half a dozen different books that applicants are supposed to read, study, and remember. Licensing fees total about $200.
That multiple-choice test, is it like the history of the city and what kind of buildings, or is it, how to give CPR to, or is it all those things?
The licensing test covers about 14 different topics, all of which are geared toward things that people might want to say on a tour. Questions about the city's architecture, the city's geography, the city's history, or my personal favorite, the city's regulations. But the key thing to remember is that tour guides in DC give a huge number of different tours. People in Washington, DC can take ghost tours, they can take food tours, they can even take movie tours. And it's actually impossible to believe that a single 100-question multiple choice test is going to be relevant to all of those different subjects.
Do you see this then as a kind of a money-making scheme for the city, and have your clients faced any threats, fines, or jail time?
Obviously, anytime the city government is requiring you to pay $200 in order to speak, the city wants that $200. But more fundamentally, I think what's going on here is what's been going on with governments for time immemorial, which is that the government thinks things would be better if it could decide who was allowed to speak, rather than letting people decide who they want to listen to. And that principle turns the First Amendment exactly on its head.
Have they faced any fines?
They haven't specifically been threatened. The new regulations DC has put forward specifically single out segways as things that are covered by the regulation. There are only 3 Segway companies in town, so that's as specific a threat as you can get in the regulations.
Is there a specific issue with Segway? I mean, does the city have a problem with Segway tours?
The city does not have a problem per se with segways. They do have some regulations that are governing segways, such as the speed at which you can travel and where you can use the sidewalk and where you must not use the sidewalk. With these regulations, we have no problem whatsoever. We observe them religiously. However, when they impose a regulation on us as to what we are allowed to say, we take exception to that. There should be no restriction on our speech, as is guaranteed by the First Amendment of the Constitution. It is quite ironic that here we stand less than 100 yards away from that very document in the heart of the city of freedom, and we are told we cannot speak about the document that is in the building behind me. I have just now broken the law. I am now subject to a penalty of 90 days in jail for what I have said to you today.
From a purely practical matter, do you have concerns about being able to pass a test, or is it the money, or do you not have a practical concern? Do you think you could just get the license as is?
It's not a practical issue, it's about the principle. No one should be told when they can speak or what they can say, and that's what we object to.
If I may add there, would you subject yourself to a practical test to do what you are doing now?
Any other questions from the group? Or we're happy to do one-on-one interviews. We'll all be available after the press conference, and if reporters want to stick around for a civilly disobedient brief Segway tour, you're all more than welcome to do that. Thank you all very much for coming.